Ladies and gentlemen, it's a well-accepted principle that everyone in this courtroom, no matter what the crime, is entitled to an aggressive and passionate defense. And after hearing counsel throughout this trial and through closing arguments, there's no doubt in anyone's mind.
Objection, Your Honor, improper argument striking a defendant of counsel's.
Objection, we will ask questions. Go ahead and their arguments at this point.
There's no doubt in anyone's mind that the defendant has in fact received an aggressive and passionate defense. But what is also obvious to everyone here is that some crimes are not defendable. And the only thing that defense can do is exactly what we told you they were going to do. Point away from the evidence. Point away from the truth of what's contained in these files, of what happened on February 13th, 2010. Let's start with defense counsel's first slide. Did you notice something about that slide when he explained the signs of intoxication? Did you notice anything missing from that slide? He put bloodshot eyes, slurred speech, poor balance, all reasonable explanations of a big car accident. What did he leave out? The unforgettable smell of alcohol permeating from the defendant. Point you away from the evidence, ladies and gentlemen. And you notice how he took each one of those and explained them independently. Of course he has bloodshot eyes, it's natural. Of course he had an unsteady gait. He just got in a car accident. Of course he had slurred speech. There may have been a head injury. That's not how you view the evidence, ladies and gentlemen. What did we discuss in voir dire? We view the evidence totality. We view everything together. We don't view everything independently in a vacuum. But let's go over those signs. Let's go over the signs of intoxication that they put up on their slide and how they attributed it to the crash. How many times did we ask about the results of that Glasgow scale? Do you understand now why we kept asking over and over? The medical records are right here. Perfect score on the Glasgow scale. No head trauma. Look through the medical records. Complaint of neck pain. No sign of concussion. No sign of head trauma. Perfect score on the Glasgow scale. Do you understand? It rules out head trauma that is causing those symptoms. That's why they left out the smell of alcohol. It relies on one test. One test. Did you notice that? How many times did Jose Zuniga say he tested this sample? 2 different vials, each of them with 2 independent tests. Taking the lowest value, still 2.5 times the legal limit. Let's focus on the blood. Defense points to spoliation, the fact that it was put up on a shelf. Did you hear defense counsel ask Adan?
Objection, Your Honor.
Did you hear defense counsel ask Adan Hernandez, the property room guy, whether they requested to preserve it? Whether they requested to retest it? No. Why? Because they know the results. They know what this is going to show.
That leaves a false impression on jury. We did request to test it.
Objection overruled.
They know the results, ladies and gentlemen. They know what these vials contain. And now they want to stand up and argue, well, it wasn't retested by us, so you have to throw it out. There's a reason.
Your Honor, it's a false impression with the jury. We did ask for it.
Objection overruled.
Did you ever hear Adan say it was spoiled? Adan's not a chemist.
Objection, Your Honor. Also, these are false impressions. The state told us that it was spoiled.
Mr. Vela.
I'm going to object to that comment, Your Honor.
Objection overruled. Mr. Vela, second.
Let's move on to consent.
Your Honor, no.
Let's move to the issue of consent. Oral consent, written consent. Right here. And most importantly, who brought you Melissa Hymas? We brought you Melissa Hymas. Clearly, co-worker of the defendant. Clearly, a threat. But when you get to that paragraph of consent, if you're having trouble deciding whether there was consent, think about her testimony. The friend of J.C. Gomez. What did she tell you as a nurse? I never draw blood unless I have the patient's consent. That's what she told you. She drew the blood. Now defense wants to say, because the police ordered it, it was coerced. They made her. They threatened her job. The police can't fire her. Who orders blood draws? Doctors. Every day she's ordered to draw blood. Every day ordered to draw blood. Why is this any different? Thousands of blood draws, she said. And she doesn't know how to do it? It's a simple needle. That's what defense wants to argue? To point you away from this. And from the officer's testimony. Let's move on to the arrest, which defense counsel keeps making a big deal out of. That it was unreasonable. That Wesley didn't follow protocol. Ladies and gentlemen, what sounds reasonable? Immediately taking someone downtown without regard to their medical safety, or giving a detailed report following proper protocol, and then leaving a suspect in the custody of the hospital so that he can receive medical treatment. Doesn't that sound more reasonable? Chain of custody. Follow the paper trail, ladies and gentlemen. We brought you all of the relevant evidence. Follow the paper trail. You heard testimony from Adan. Temporary fridge, locked, February 13th. Adan comes in on a hectic Monday morning. First thing he does, log it in. February 15th, 2010, 9 a.m. Right when he walks in the door. Long-term fridge. They want to say there's breaks in the links. We brought you Adan. They couldn't break Adan. He pulled it out of the long-term fridge like he told you. Took it down to DPS in that mailable canister after consulting with Jose Zuniga on the proper method of transport. Followed every protocol. Follow the paper trail. Received at DPS, you know that sticker. February 18, 2013. It's on 2010, it's on there. Tested by Jose Zuniga, following proper protocol at DPS. Follow the paper trail, ladies and gentlemen. It's all here. And lastly, ladies and gentlemen, and most importantly, defense stood up here and commented, tried to dissect all the little mistakes made by everybody. PD, even fire department, medical staff, all the mistakes in this investigation, in the testing. What did they ignore? How about the mistakes that Juan Carlos Gomez made on February 13, 2010? How about his first mistake, when he took that first sip of alcohol? And every sip after that. Mistake after mistake. How about the mistake of him walking to his car? How about the mistake of him reaching for his keys? What about the mistake of him putting those keys in the door to unlock his truck? And what about the mistake of putting those keys in the ignition of a 3,000-pound machine and getting behind the wheel intoxicated? Ladies and gentlemen, defense counsel stood in front of you and said, you are the last line of defense of our rights. What you need to know is that you are also the last line of defense in law enforcement. Police are the first line. Comes to our office, we analyze the case. Then it's presented to you guys. You are the last line of defense in law enforcement. Don't make another mistake by putting an intoxicated driver back on our streets.
Thank you.